Minash-shaytanir-rajim. Bismillahir-rahmanir-rahim. Iyyaka na'budu wa iyyaka nasta'in. Justice Shabi Siddiq, the senior judge of this court, my brother judges of this court, Mr. Rehan Aziz Malik, the President Sindh High Court Bar Association, Mr. Sarfraz Ali Netlo, the Secretary Sindh High Court Bar Association, the entire management of the Sindh High Court Bar Association, all the worthy guests, the worthy registrar, the lady and gent advocates, my brother and sisters, the media personnel, Assalamu Alaikum. Unfortunately, today I am having a low voice because of lot of work and some programs which I have recently attended. So I have requested the organizer to kindly allow me to say a few words. Otherwise, I was required to address you at the end of the seminar. But my brother judges and I having heavy workload on judicial side as well as administrative side. That's why I have come prior to the learned speakers. I would like to congratulate Mr. Ishaq, who is the perhaps CEO of the MIA, and the Sindh High Court Bar Association, who have arranged this seminar. The purpose of this seminar is, of course, to somehow highlight the importance of the mediation with regard to the dispute resolution. You see, it might not have the legal backing as such because there are hardly any statutory provision whereby you can insist a party to come to the mediation. So it requires a persuasion and giving the understanding to the litigant parties to try to resolve their dispute through mediation. And of course, it depends upon the nature of the society in which you are living. It requires to be educated, and perhaps this is the purpose of this MIA as well as other mediation centers. We have as such recognized or allowed 2 mediation centers under the auspices of the Sindh High Court because we recognize and we want that the workload which is on the courts, high courts and as well as court, can be somehow reduced. So I have prepared some bullet points, so I'll give you some bullet points for information with regard to the today's topic. In my understanding, mediation is a collaborative approach aiming to resolve disputes amicably without going through traditional litigation process. Not only the benefits of mediation is an alternative to the formal litigation, but also the success of mediation is in various jurisdictions is now recognized worldwide. You can understand that. Countries such as the United States, Australia, and several European nations have embraced mediation as a, I'm sorry, I'm not having my glasses, cornerstone of their legal system. The benefits of mediation, including its cost effectiveness, swiftness, and preservation of relationship, have led to its widespread adoption in commercial, civil, and even family disputes. Considering the successful evolution of alternate dispute resolution, the provincial legislature enacted the Code of Civil Procedure, the Sindh Amendment Act 2018, whereby the amendments and insertions have been made in Section 89A, 89B, and Order 10 Rule 1A to 1D CPC, thereby providing complete mechanism as to mediation of cases. But this is not enough, according to me. It requires further, perhaps, enactments so that the mediation can be given some sort of a legal cover as well. Then, to facilitate the mediation, the Sindh High Court has established a court annex mediation center within its premises at Karachi with the primary aim of promoting expeditious resolution of disputes through mediation in cases referred to the center by the courts. The center is effectively working since 11th August 2023. The progress at court annexed mediation center is monitored by Mr. Justice Adnan Iqbal Chaudhry in his capacity as member of the ADR committee, which has been constituted by the Honorable Chief Justice of Pakistan for implementing the legal framework of the ADR in Pakistan. Though it has a different scope, ADR has a legal backing, but somehow it is relatable to the subject. Presently, 2 judicial officers, a senior civil judge and a civil family judge, are actively working as mediators to conduct mediation in cases referred by the Sindh High Court, Karachi, and 5 district courts of Karachi. So far, a total of 49 cases have been referred to court and next mediation center by the different courts, including Sindh High Court, since 11 August 2023, out of which 21 of them culminated into a settlement and 16 cases disputes returned unsuccessful, while 12 cases disputes are still under mediation. So it is a reasonable, you can say, a success rate. The success ratio in mediation of cases so far is 57%. It will increase inshallah, which is encouraging and indicating a positive trend in outcomes. Besides courts and its mediation center, the Sindh High Court has also recognized 2 organizations, namely MIC, ADR, who have arranged this program today. इसको ग़ालिबन ये इसका पूरा है मुसालिहा इंटरनेशनल सेंटर फॉर आर्बिट्रेशन एंड डिस्प्यूट रेजोल्यूशन. बहरहाल इन्होंने इंग्लिश और उर्दू का अच्छा कॉम्बिनेशन किया है. And IBA Karachi has approved ADR center, which are also actively working. The seminar organized today by the Sindh High Court Bar Association marks a significant stride towards promoting mediation. This initiative not only promises expedited resolution of the dispute for litigants, but also showcases the potential effectiveness compared to the prolonged litigation. Moreover, it is anticipated that mediation will alleviate the burden of the courts in the long run and prove beneficial for the entire legal fraternity. So having said this, I would like to take advantage of my audience because आप सारे advocates हैं माशाल्लाह, और ये बार एसोसिएशन में मुझे सारी पुरानी रेट्रोस्पेक्ट मिलेगी. आप सबसे कुछ बातें करना चाहूँगा इस मौके के हवाले से. हम सब का और आपका लॉयर्स का, जुडिशरी का एक ही प्राइम पर्पस है, to provide justice to every citizen of the Pakistan. ये टास्क मुश्किल है, लेकिन मुश्किल है मगर नामुमकिन नहीं है. ये स्टार्ट होता है आपके दफ्तरों से, और बहुत कम परसेंटेज है जिसमें लोग इन पर्सन आते हैं, जो कुछ होता है. आपके दफ्तरों से लिटिगेशन स्टार्ट होती है. आप लोग से रिक्वेस्ट करूँगा, और जो मैं बार बार कहता हूँ, कि अल्लाह ने रिस्क का वादा किया हुआ है, वो आपको रिस्क जो आपका मुतय्यन है ज़रूर देगा. आप ईमानदारी से, दयानतदारी से अपने क्लाइंट की जो भी आप मदद कर सकते हैं कानूनी, आप उसको हमेशा इनिशियल जो फर्स्ट टाइम आपके पास आता है लिटिगेंट, आप उसको हमेशा सिंसियर और ट्रू एडवाइस दीजिए अकॉर्डिंग टू लॉ. सुने उसको और ट्राई टू कन्विंस हिम दैट इफ़ द मैटर कैन बी रिजॉल्व आउटसाइड द कोर्ट, ऑफ कोर्स यू कैन चार्ज योर फी. ऐसा नहीं है कि वो खुदा न खास्ता आपको फ़ी ना दे, मगर यूजुअली ये होता है. प्रैक्टिकल एस्पेक्ट्स ये वो कहते हैं कि वकील साहब ने तो बस मशवरा दे के कर दिया, अस्सलाम वालेकुम, और वो चले जाते हैं. लेकिन बट इन एनी केस आई डोंट नो वेदर आप इसको कोई लीगल कवर दे सकते हैं, बट और द एडवोकेट कैन इंसिस्ट इफ़ यू आर कमिंग टू मी फॉर एन एडवाइस आई विल चार्ज यू दिस. और उस एडवाइस में आप इस चीज़ को शामिल कर दें कि अगर कोर्ट में जाने की ज़रूरत नहीं है और ये मामला रिजॉल्व हो सकता है, या कोई दूसरी पार्टी है या उसका दूसरा एडवोकेट है, आप उसके साथ बैठ के रिजॉल्व कर सकते हैं, प्रोवाइडेड कि वो आपको आपकी फ़ी दे दे ऑफ कोर्स. तो ये अननेसेसरी लिटिगेशन माजरत के साथ और फ्राइवलेस लिटिगेशन में अनफॉर्चुनेटली जब अपने साथियों के साथ बैठता हूँ तो इस चीज़ का बहुत इजहार करते हैं कि हमारा सारा वक्त जो है फ्राइवलेस लिटिगेशन को रिजॉल्व करने में निकल जाता है. और अनफॉर्चुनेटली जो एक्चुअल लिटिगेशन है, जो डिस्प्यूट्स हैं जिनको कानूनी उसकी ज़रूरत होती है,